Monday, 24 August 2026. 3 Asia-Pacific AI stories before your first coffee. Seoul's National Assembly passed a Personal Information Protection Act amendment on 20 August, clearing companies to train AI models on lawfully collected personal data without individual consent, subject to case-by-case approval from the Privacy Commission. The new pathway requires prior risk assessments and published processing policies, with first applications reviewed in 30 days and similar cases fast-tracked in 15, and it takes effect 6 months after promulgation. Separately, a Japanese government intellectual property panel approved a comply or explain code on 18 August, requiring generative AI developers to disclose their models, training data sources, and collection methods. Why it matters? These 2 moves set competing templates for how Asia's largest AI economies handle the training data bottleneck. Korea's consent-free pathway gives domestic builders like Naver and Kakao a faster route to scale foundation models on local data. But the case-by-case approval gate means the Privacy Commission becomes a de facto gatekeeper for model development timelines. Japan's disclosure code, while softer in enforcement, creates a transparency baseline that could become the reference standard for trade partners still drafting rules, including Australia, whose national AI standards remain with National Cabinet on an early 2027 legislative timetable. Compliance teams across the region should watch Korea's first batch of approvals closely. The speed and scope of those rulings will signal whether the framework genuinely accelerates training or simply relocates the bottleneck from consent collection to regulatory queue. So, Alibaba is placing roughly 710 million new shares at 112.7 Hong Kong dollars each, raising about 80 billion Hong Kong dollars in what is the largest primary follow-on offering ever by a Hong Kong-listed company. Every dollar of net proceeds is earmarked for full-stack AI, chips, infrastructure, and model development and deployment. The raise lands days after Alibaba reported June quarter net income of just 10.44 billion yuan, down roughly 3/4, while capital expenditure hit 67.68 billion yuan in the same period, as the company accelerates spending on its 3-year, 380 billion yuan capacity plan, which is now exactly half deployed. Why it matters? Alibaba is explicitly converting equity into compute at a moment when its earnings can no longer self-fund the AI build-out at the pace management wants. Capital allocators across Asia should note the signal. Even the region's largest cloud provider is tapping public markets rather than slowing its infrastructure rollout. Builders relying on Alibaba Cloud for inference and training capacity stand to benefit from faster rack deployment, but the dilution, roughly 5% of shares outstanding, pressures near-term returns and may cool sentiment across Hong Kong-listed tech names. One second-order effect worth tracking is whether Tencent or Baidu follow with their own capital raises to keep pace, turning Hong Kong into the primary funding venue for Asia's AI infrastructure arms race. Now, the Dutch Data Protection Authority fined Uber 825 million euros for automated driver account suspensions, marking the second largest penalty ever issued under the European Union's data protection regulation. Uber plans to appeal, but the ruling puts a hard price tag on deactivation algorithms, the same systems that ride-hailing and delivery platforms run across Southeast Asia. Singapore's Platform Workers Act, Malaysia's Gig Workers Act 2025, and Indonesia's pending gig economy bill collectively cover millions of workers, yet none of them require platforms to explain or justify automated decisions that suspend or terminate driver accounts. Why it matters? The Dutch ruling creates a reference price for algorithmic accountability that ASEAN regulators have not yet set. Singapore's law addresses injury compensation, retirement contributions, and representation, but stops short of automated decision rights. Malaysia's statute, effective since 31st March and covering over 1.6 million workers, similarly omits algorithmic transparency requirements. Indonesia has no dedicated law at all, only a bill sitting on the 2026 legislative priority list. Platform operators building across the region face a widening compliance gap. European exposure now carries 9-figure penalties, while Southeast Asian operations run identical systems with no equivalent obligation. Capital allocators backing regional super apps should watch whether any ASEAN regulator uses the Dutch precedent to draft local algorithmic accountability rules, because retroactive enforcement modeled on the EU playbook would reshape unit economics overnight. That is your AI in Asia briefing for today. Stay sharp, build well, see you tomorrow.